So now up, Nancy Sher-Cohen and Kim Winter from our insurance recovery group are going to talk about business interruption coverage and other insurance coverage related issues that have really kept our insurance recovery group humming these last couple of weeks. Nancy and Kim, take it away.
Thank you very much. Can everybody hear me okay? Brian, can you hear me? Good. Okay, very good. So why don't we go to the next slide? I'm Nancy Sher-Cohen. I am a trial lawyer. I have had many jury trial opportunities over the last 40 years. I have recovered over $1.5 billion for our clients, who are always policyholders. And my specialty, as you can clearly tell, is insurance coverage on behalf of policyholders. And I just pointed out that we're busier than ever pursuing insurance carriers, particularly in the world of COVID. So that's who I am. Kim Winter is going to talk next. Kim is also going to continue our discussion by going through a number of our next slides. Kim?
Thanks, Nancy. Good afternoon. Thanks for sticking around. You're in the home stretch. I'm Kim Winter. I'm a partner in our Kansas City office in the Insurance Recovery and Counseling Group. I've been practicing insurance law in one form or another for more than 22 years. And it has been 100% of my practice since joining Lathrop 16 and a half years ago. In all that time, I don't know that I have ever said that it was an exciting time to be an insurance recovery lawyer, unironically, until now. It really is an exciting time to be an insurance coverage lawyer. So next slide, please. So we're going to focus today on COVID-19 related losses and specifically business interruption coverage, also known as time element or business income loss coverage. You may see those terms in your policies as well. But before we jump into the substance of our presentation, we wanted to ask a couple of questions of you. We'd just like to get an idea of your experience with business interruption losses related to COVID and sort of your insurance coverage claim experience so far. So you'll see there are 3 questions up on your screen. First of all, have you or your organization made a claim for coverage, or do you plan to make such a claim for losses related to COVID-19? The next question is, if so, what is the extent of your anticipated losses? And then you'll see question 3 is, if you have already submitted a claim for coverage, what is the status of that claim? So we'll give you a little bit of time to answer those questions. And please answer all 3 of them. Okay, looks like a good portion of you have not submitted a claim yet, or you don't plan to submit a claim. But for about a quarter of you, it's undecided, and 6% have already done it. And then of those that have submitted or plan to submit, a lot of you are unknown, which is not surprising. There are a lot of factors still to consider. Some have over 10 million, there's 2.5 million to 5 million, and then there's 8% in the 0 to 500,000 range. So it's sort of an interesting mix. And then for those of you that have submitted a claim for coverage, it looks like carrier has not responded, it's about 4%. 1% of you have gotten a reservation of rights, and then 3% they have denied the claim. So it's an interesting mix. Okay, so jumping right in here, let's focus, let's next slide, please. All right, so we're going to start by looking at some of the business interruption coverage issues. And there are a lot of different types of losses and policies that might apply to those losses related to COVID. You might have workers' compensation claims. You might have a liability claim that somebody made against your business that could trigger your general liability coverage. You might even have a shareholder claim that triggers your directors and officers policies. But today we're focused on business interruption, which will typically fall under first-party property policies. And these policies vary greatly. There really isn't a standard form. However, they virtually all require that the insured show some kind of direct physical loss or damage to covered property. So, when your property is damaged by a fire or a hurricane or a flood, there's typically no question that you've suffered direct physical damage. But what about damage caused by a virus? Is that direct physical damage? That's the question. It's a threshold issue in coverage in this situation. So first of all, do you have to have overt, tangible changes to your property? What about microscopic changes? Not many courts have decided this issue, and the few that have are split. So on the one hand, we have courts in California and Kentucky, for example, that have found coverage in situations involving damage caused by mold, odor, mildew, even overheating computer components where there was a data loss. On the other hand, some courts in Michigan and Oregon, for example, have found that foul odors and other microscopic damage is not enough. You have to have distinct and demonstrable physical damage. What about loss of use? Can physical damage include loss of use without more? Again, it varies by jurisdiction, but in some cases, courts have said yes. In California and Arizona, for example, there are opinions finding that property damage includes loss of use without any other physical damage, so something to keep in mind. And the burden of proof to show that there has been direct physical loss or damage is on the policyholder. So what should you be looking for? Do you have direct evidence that someone exposed to the virus was present at an insured location? It could be a customer, it could be a vendor, it could be an employee. Do you have that direct evidence? If you don't, is there some other way that you might be able to show coverage or that contamination occurred? Some policies have civil authority coverage that could apply here because of the various shutdown orders around the country. And in those cases, you don't usually have to show direct physical damage at your own location, but you may have to show that the civil authority arises out of direct physical loss nearby. Some policies say within a 5-mile radius, some say within a 1-mile radius, some aren't that specific. But again, we still have that underlying issue of whether damage from a virus is direct physical loss. And the fact that there's been difficulty testing and unavailability of testing might actually help policyholders here. It's possible that policyholders might be able to look to experts, epidemiologists or statisticians, to show that, given the numbers in the surrounding vicinity, it's more likely than not that you had someone who tested positive at your location at a particular time. So that's something else to think about. So let's say that you can show actual or presumed contamination at a particular point in time. The next question becomes whether the property damage is ongoing as a result of that particular exposure. So how much business interruption was caused by that exposure? Are there multiple exposures happening? These are all things to consider. Next slide, please.
Kim, before you go further, there has been a question that came up about whether you can get damages for loss of use in Missouri. Do you know the answer to that?
That is an open question. So we don't know yet. So next slide, please. So another consideration is whether your policy has a pollution exclusion, and does that pollution exclusion define contaminant or pollutant to include virus? We've seen some that do and others that don't, so you definitely want to check the wording. And you may also have a separate policy for pollution coverage that could apply here. These policies typically provide coverage for damage caused by the contaminant, including cleanup costs, and they may even include business interruption coverage. So don't forget to look to these policies if that's something that you've purchased. And then virus exclusions are another major issue here. At the beginning of the pandemic, there were a lot of insurance companies and brokers proclaiming outright that there was no way there was going to be coverage for COVID-19 because these policies all contain virus exclusions. While many policies do contain virus exclusions of one sort or another, not all of them do, and they're not created equal. Some exclusions are much broader than others. So Just because you have a virus exclusion in your policy, that does not necessarily mean that there's no hope for coverage. And the fact that some policies contain a virus exclusion sort of begs the question, if damage from a virus could never be direct physical loss, why did so many insurance companies find it necessary to put that exclusion in there in the first place? And just as a little background, virus exclusions first appeared about 15 years ago in response to the bird flu scare. The language from the standard ISO form is in the slide if you want to read through it. You'll notice that the language refers to virus, bacterium, or other microorganism. It does not mention coronavirus or SARS specifically, nor does it mention pandemic. Now, we have seen a few exclusions that do specifically mention these things, which could be a bigger problem. And if you've recently renewed, no doubt you've seen a much more specific and robust exclusion that does specifically mention COVID and coronavirus. But the bottom line is, don't assume that virus exclusions automatically mean that your claim is without merit. A lot depends on your particular policy language and the law of the relevant jurisdiction. Next slide, please. Another issue is whether your business must completely shut down or is a slowdown enough. First and foremost, you want to check your policy language because many of them are very specific about this. They may say you need a suspension of operations, which might sound like complete shutdown, but then suspension is defined to include a slowdown. Other policies refer to a total or partial suspension of business. So if you remained open throughout the pandemic, but you were limited in what you could do, like restaurants that could do, takeout and delivery service only, is that enough? Well, again, it really depends on your policy, so you need to check the wording carefully. And one more thing to keep in mind on this topic, these policies typically require that you mitigate your damages and at least partially reopen as soon as possible. So it seems a bit incongruous to say that your business had to be completely shut down in order for coverage to apply, when the insurer is simultaneously requiring you to partially open or partially operate as soon as possible to mitigate the loss. So something to keep in mind there. Next slide, please. So once you establish that you have a covered business interruption claim, the issue becomes, what is that claim worth? How will it be calculated? Often the policy has fairly specific provisions about this, but there's always going to be room to argue. So we've listed some sample policy language here about how damage might be calculated. And you'll see here, it's based on the actual experience of the business, both before and after the loss period, as well as the probable experience during the loss period. So how do you determine the probable experience? The policy states here that any increase or decrease in demand for your goods and services during the period of liability will be considered. So in other words, insurers could say that these stay-at-home orders, the mass protests, any general decreased demand is going to be a way for them to try and limit your loss here. So something to keep in mind. And then finally, what about PPP funds? If you received a Paycheck Protection Program loan, that may be counted against your loss, especially if the loan is ultimately forgiven. That makes sense. You can't double dip. But what if you have to pay it back? It still might have the effect of shifting your indemnity period, essentially, which could have an impact on your claim. So something to think about. Next slide, please. Finally, before I turn this over to Nancy to finish up, I just want to mention that there are certain policies that contain specific communicable disease coverage, basically the opposite of the virus exclusion. These policies provide some coverage for this type of loss. However, the ones that we have seen most often have very limited coverage. So you might have a $200 million property policy, but it has a $250,000 communicable disease sublimit, so it's not nearly as valuable as you might have thought. The other issue is these typically include language that require the actual not suspected presence of communicable disease at a covered location, plus limited access to such location, either by civil authority or by decision of an officer of the company. So this might complicate your claim if you're unable to demonstrate that there was actually someone at your location that was positive for the virus, or if access to your location wasn't officially limited. So all things to keep in mind, and that's all I have, and I will turn it back to Nancy.
Thanks a lot, Kim. So I start with this slide, no insurance for you. This is from Seinfeld, as most of you probably know. And that is certainly what it feels like. We have been inundated with clients who want to make claims, many of whom do not have virus exclusions thought that they would have coverage in this event and are finding that based upon the things you heard from Kim, there really aren't going to be, they aren't going to be able to get coverage. So what has happened? There has been an effort by the policyholder bar and the many insureds to see if there can be legislative intervention, to see whether there's a way to litigate these cases on a more efficient basis rather than having, for example, a little restaurant that thinks it has insurance on its own to make claims and try to take on an insurance carrier. So that's what I would like to talk about. What is the status of those efforts? So next slide. So here is the situation on the insurance litigation. There have been hundreds of cases that have been filed nationwide. Interestingly, there are a number of plaintiffs' firms that have not been involved in these kinds of cases before involving insurance, but instead have been personal injury lawyers who have jumped into the fray. And so to date, we have 100 federal cases, 350 cases all over the country in state courts. Most interestingly, two things have happened. There has been an effort to have a class action. We've been highly skeptical that's going to work. And in fact, there isn't any case that has gotten class certification yet. The key issue, as I'm sure many of you know, is whether or not there are common questions of law in fact. And there are different state laws on these things. So the damages are individualized. The questions of fact are very individualized. And in many cases, some of the law is individualized because each policy has different language on exclusions and how it applies to the particular insured. So I don't think the class actions are going to be the way of efficiently and quickly litigating this. So then there's been an effort to have a multi-district litigation, an MDL. And there was a filing in Florida that has been an effort by the policyholder lawyers to consolidate this into an MDL. This is really an interesting issue. Is that something that we should do? Is it something we should not do? And I wanted on the slide to reflect the fact that, you know, it's not very clear the answer to that. I'm a member of the American College of Coverage Counsel, as is Kim, and they ran a survey. Now that group includes policyholder lawyers and insurance company lawyers. And the question was, do you think we should have an MDL? And should we take a position? Remarkably, there was absolutely no agreement. Some of the carrier counsel said we should, some said we shouldn't. Same's true for the policyholders. The pros are, as you can see here, there's a lower cost if you just do it that way. You can have a bunch of plaintiffs' lawyers tagging along to who's ever been sort of designated as the lead. You know, the judge will most likely understand the law because it'll be assigned to that person who is knowledgeable about insurance laws. But, you know, there's going to be increased cost to distinguish your facts and applicable law because you're in a different position. You know, you might, for example, be in a good insurance jurisdiction. California, for example, is a lot better than Missouri and Kansas on this law. So wherever it gets sent, it may not be a good jurisdiction for the group. So given all of that, we have not entered into that fray yet. I can give you an update, which is we expect a hearing next week to determine whether, in fact, there's going to be an MDL ordered, and we expect a decision on that question in August. But that would be sort of big news if it does get sent to MDL, because that means all the federal cases, no matter where you file them, will get sent to the judge who's handling the MDL. Next slide. So I want to talk for a minute about what's happening and what decisions have been made, because I think, you know, that sort of tells you in an important way, you know, what's out there. And the answer to that is there aren't a lot of decisions, but unfortunately, they're not going to be very good. There's a case from the Pennsylvania Supreme Court called Tambellini, and the insured's application to expedite the coverage decision because they were in financial trouble given COVID-19, that was denied. There'll be no, we're not going to decide this expeditiously. There's a case in the Southern District of New York where the policyholder moved for a preliminary injunction. This was denied. This is from a policyholder perspective, a particularly bad case. The court found that the plaintiff was unlikely to succeed on the merits, which is why the judge refused to issue the injunction. You know, when in making a decision about whether in fact to seek a preliminary injunction, one has to think through what happens if that's the decision. I'm not sure the plaintiff's lawyers here did that, or if they did, I'm not sure I agree with their conclusion to go ahead and ask for a preliminary injunction, because at the end of the day, their case is basically out early on before they've even done discovery, I might add. Then there's a case in the Michigan courts where the case was dismissed because the complaint didn't allege tangible alteration to property and there was a virus exclusion. So that's the issue that Kim talked about, which is the property damage plus a virus exclusion. So at the moment, the policyholders have not been doing well. We're hoping at some point to change that momentum, but the cases have not been favorable. Next slide. That led everybody to start thinking about, well, maybe we can get some legislation to help us out. So next slide. So I wanted to have a slide here where we talked a little bit about what's happening, and there's several things. The first one is what I call the TRIA issue. You might recall that after 9/11, there was a question about whether anyone would be able to get terrorism coverage going forward. And so legislation was passed where there was risk sharing between the government and the insurance companies so that terrorism coverage could be written after 9/11, but the insurance companies wouldn't have to bear that burden by itself. So there has been the thought that we needed to do the same thing having to do with COVID-19 and viruses and pandemics. And so there are a number of bills pending, which I have listed here, mostly in the House Committee on Financial Services, which tried to deal with this question of what's going to happen to your insurance going forward. So one of them requires the insurers to make available coverage for viral pandemic and forced closure of businesses. And the exclusions that prevent that would be void. And, you know, as I said, there would be cost sharing going on between the federal government and the carriers. Initially, the carriers have been positive about this, but recently there's been a lot of pushback. So I can't tell you I know what's going to happen. The second one I mentioned here is effective upon the Treasury certification of federal reinsurance backstop mechanism. Insurers have to offer BI coverage due to forced closures during a national emergency for at least 30 days. So assuming you actually got the government to agree that they were going to help backstop the carriers, then this sets a limit of 30 days and says that's the minimum that you can offer. And then finally, you've got the Pandemic Risk and Reinsurance Program, which is more voluntary. Although the federal government takes on 95% of the business interruption risk excess of $250 billion, that's also stuck in committee. So I can't tell you how this is going to come out, although there is a general sense that people do want to be able to purchase pandemic insurance, if you will, and that the government should step in. Even the carriers are feeling that in many cases that there should be a government involvement here to make sure people can have coverage going forward. Next slide. There's also legislation going on in the states. And so you can see the states. I'm sure many of them are not a surprise, although I suppose some of them might be. The key components of that legislation is to go back in time and to say, well, I know what the policies say, but we want retroactive application of these new rules. And the new rules are that COVID-19 is a covered cause of business interruption, that there shouldn't be any denials for lack of physical damage or a virus exclusion, that the carrier's reimbursement or funding scheme should be funded by industry assessments or voluntary participation, and that finally there should be caps on claim payments and reimbursements in exchange for bad faith liability waivers. At the moment, none of those have gone anywhere either. And, but there's a lot of activity, and I wanted to at least point out a few problems that we see with that. Next slide. So these are the states. I wanted you to know where they were, what the general locations were, and what the bill numbers are so that you would have them. And we put in the slide, life support, do not unplug, because as best we can tell, I mean, this has been going on for months now, these state legislative initiatives, and not one of them is passed. So I don't want to, give you too much hope on this front. Next slide. So here's why. It's one thing to say the government's going to risk share with insurance companies going forward. It's another thing to change the meaning and the terms of a contract between the insureds and the insurers. So the first challenge we think would happen to any state legislation that tries to do that is obviously the contract clause of the US Constitution, which says in effect that you can't impair the obligation of contracts. And so the question on the table would be, do the reimbursement schemes undercut the impairment, especially since the insurance is highly regulated? It's an argument, but I think it's an uphill argument. And so I think that's another reason these state initiatives have sort of stalled. Next slide. And then it's a taking. I mean, that's the argument that when you have a contract, you have a deal, that when the government comes in and says, I'm changing the deal, then, there's an argument that in fact contracts are property and the government is in effect taking them by changing those terms. And so we have the same question, does a reimbursement scheme recovering amounts paid undercut a takings claim? Hard to know, but I think our conclusion is that changing the terms of the contract through legislative initiatives in the state legislatures is probably not going to go very far, and that it will be under a lot of legal attack and not likely to succeed. Next slide. So here are our key takeaways. It doesn't appear that legislation is on its way to rescue the policyholders. And even if they passed, the courts will probably press the pause button to address any constitutional issues. And I think our hope is where you're going to see legislation is in the area of risk sharing going forward, because I bet many of you would love to be able to purchase pandemic business interruption coverage going forward if it was somewhat reasonably priced. And you could actually get it. So I think that's the most likely area you are likely to see some legislative success. So with that, Kim, I think that's it. I guess you can talk. Why don't you, Kim, you talk a little bit about our final recommendations.
Oh, sure. So for those of you that are on the fence or undecided, we do recommend that you make a claim sooner rather than later. Obviously, you want to document any losses that you have. You want to seek qualified representation. Don't take the insurance company's word for it or the broker's word for it that you don't have coverage unless you've had someone who's really familiar with this type of work or do your policy. And then, don't take no for an answer. And as I mentioned earlier, insurance companies and brokers were sort of saying across the board, there's no way there's coverage for any of this. And although there have been some decisions that have not been terribly policyholder favorable yet, there's a lot that's unknown. And so just make sure that you don't take no for an answer without having someone really thoroughly review it and thinking of all the different arguments. And that's it.
Well, thank you, Nancy and Kim, and to the whole insurance recovery group. We know you guys have been hustling really hard on behalf of all of our clients for these last several months, and thanks for everything you do. And thanks to everybody who joined us today for session 2 of our 3-part series on the state of litigation. Just as a reminder, session 3 is next Thursday, same time, same place. And the video recordings of today's session and session 1 are out on our website. Session 1 is already there, and session 2, today's discussions, will be out on our website within the next 24 to 48 hours. Thanks very much, everybody. Enjoy the rest of the day and have a great weekend.